Afternoon and welcome everyone. My name is Adrienne Brown and I'm with the Little Rock chapter of the Links Incorporated. And I want to thank Garbo Hearn for giving me the opportunity to facilitate today's session with you all today. This is the first Wisdom Wednesday of November. Want to tell you a little bit about the space that we're in today. We are at Pyramid Art Book and Custom Framing. And this location has really been made to elevate and showcase Black culture through literature and fine art. Pyramid Art, Books, and Custom Framing offers a platform for local, regional, and international artists and authors. And right now we are in the primary gallery, and I'll tell you a little bit more about it later. But I want to tell you about Wisdom Wednesdays. This program has been specifically curated for people who are either already retired or on the verge of retirement. Garbo had a vision for this program to help people who may be transitioning, if you will, in terms of life's events, and wanted to ensure that you had access to topics that are important to you. And so today we have a very important topic, which is estate planning with attorney Pam Abrams. And I'm going to turn it over to you to get us started with the session, and I'll be back later. Thank you.
Okay, I'd like to thank everyone for coming out and those that are watching us online as well. Of course, there's not a lot I could teach you all in an hour and a half. So this is going to be very basic. One thing to remember, everyone's estate plan is different. Each one is a unique situation. But as I go through some just basic terminology, I know that some people get things mixed up and they talk to people, they see things on TV. Well, this will help you get a better understanding of some of the terminology, some tips on how to make a good estate plan, some things that really don't get included in estate planning that doesn't require, a lawyer or anything like that for. And lastly, points to consider. Please stop me if you do have a question. We will have time in the end as well. So we're going to start out. I did not write these books, but I did ask Garbo to order them because I found them to be for the beginning, the basic type of training that I do with groups. This one, you've seen this lady's commercial. Um, Nash Law Firm. If you have two relatives and a dollar, you need to do some estate planning. Uh, and I was thinking about it. She has some horror stories in here. I mean, stories that you just would not believe. But believe me when I said I have had clients come to me with some of the same horror stories. And it's just greed. Money makes people do things. They change completely. I've seen some stories where one situation, there was one sibling that was kind of estranged, but when mama died, um, she called in sick and didn't come to the funeral. By the time the family got back after the interment, that house was cleaned out. She said mama always wanted her to have everything. Mama wasn't there to, it wasn't written down. So the families, they want to call the police. The police first thing they're going to tell you is, this is not criminal. This is a civil matter, and there's absolutely nothing we could do about it. And so just remember, criminal, the prosecuting attorney steps in and decides the case is important enough for them to go after. So most of these situations, it won't happen. A lot of people deal with this as well. You have a family, getting, elderly couple, they have two kids. One did very well, moved out of the state, got married, never asked for any financial help. And then you have the brother who had a history of drug and alcohol, who always depended on mama and daddy to get him out of it. He saw an opportunity when the father got sick, and this is another mistake people make. And Jill Jones, our last speaker, talked about it. How you are totally unprepared if only one person in your marriage knows the codes, the online stuff, even your social media. Simple things. I don't do a lot of Facebook, but I do like to do birthdays. So that's the one thing easy I can do. Happy birthday, happy birthday. But now I have to actually look and see, is that person still alive? And then I start seeing things like happy heavenly birthday. Should that Facebook post, should that account be eliminated? What's the purpose? But if you don't have it set up with Facebook, you can't even go in there to have it deleted. So you can do some things while you're live, like that, something simple like that, that allows you to designate someone to get that. So I would encourage you, and unfortunately we're just full of passwords and things like that. But you really need to write it down somewhere and have it available. I think I need to like stream down some of my stuff because that list is like 2.5 pages now. Some people say I use the same password for everything. Well, they don't allow that anymore. And so you have to be careful about that. But let's just jump into it. It's a lot of horror stories. She puts in here. Um, the first term I want to talk about is the beneficiary. Now, that's just whoever that person decides will get something only after that person passes away. That needs to be looked at because people change, situations change, and the wheels don't change. And so make sure you update your beneficiaries at all times. Now, I've seen wills where mama has put in there, I want to divide everything up between my 4 children. But then the insurance beneficiary is, guess what? Only one of those children. And so that child really doesn't have to do anything. And I see that a lot. And so you can have more than one beneficiary. Those things don't go through probate. You could put in the will, I want you to divide it up, but it's strictly between the insurance company and that beneficiary. So always update your beneficiaries, and as things change, make sure you change. A lot of people ask me, do I need a will or do I need probate? Probate is so hot right now. Everybody wants a trust, and I tell people, well, it just depends on what assets, that you have and what you want done with those assets. But the will is the foundation of all estate planning. If you don't need anything else, you need that will. But remember, beneficiaries override the will. Okay. Executor, that's associated with the will. That's the person that's gonna make sure your wishes are taken care of. Executor, the trust that's really hot right now. You have a couple of them. One is revocable, which you can change, and that's also called a living trust. So people come, I want a living will. Well, living will, when I hear that, that goes to healthcare for me. So be very clear about your terms. There's also an irrevocable, and very few people need that unless you're trying to preserve, like scholarship money for your family from now on, and you don't want it to ever change. But the revocable, you can change it at any point, and you should review it at least once a year. There's another one called special needs. Many families have a child that is developmentally disabled, that won't be able to take care of themselves. And the mother and father want to make sure this child gets taken care of. But even then, they're trusting when they name someone as the trustee for a special needs account that that person will do well. But you'll find a story in here. The brother, as soon as the parents died, he stuck his brother in a facility. And that is not what they wanted. A trustee can be you while you're living. And then once you pass, you have a successor trustee. and you could have more than one. So that's important. The power of attorney is one of the easiest, most dangerous documents you could sign because it dies with you. So I have some clients comment, "Oh, I have the power of attorney." Well, they're deceased. It died with them. And a lot of people think that that just gives them the power to go and no, you have no power at that point. But the reason it's dangerous is because a lot of our, seasoned citizens will trust a child or someone else, a sibling, to have that power of attorney. Now they can specify the power of attorney doesn't kick in until that person is incapacitated. But most of them just sign it, a general durable power of attorney, and they can wipe you out. There's a horror story in there how, just wiped out all the accounts with that power of attorney. No one has to call and check. Are you sure you want them doing this? Now, some banks are really good. I knew a lady who, really was starting to decline mentally, and the bank finally figured out she was being ripped off, by someone, and so they shut down her account. But that's because she had a long-standing relationship with Regions, and they knew she was getting scammed. She didn't, but they knew. So that power of attorney, even though it's simple, anybody can print it off the internet and get it notarized. Doesn't require witnesses, and then off they go to your bank accounts. So be very, very careful about that. The power of attorney for healthcare is often mistaken for a living will, and that's why you're alive. This person can make decisions about your healthcare, decisions about what should happen to you should you become incapacitated. So that's all I advise that for everyone: a basic will and the power of attorney for healthcare. Sometimes it's called an advance directive, and a lot of hospitals now require those, which kind of lets you know if you go in a coma what you really, really want. So that's something I would encourage everyone to have. Doesn't require an attorney. It's just that, oh, now this one does require two witnesses and notary. A lot of people say probate. Probate in Arkansas is really two different things. One is for estates that are $100,000 and less. Those are the ones that I do. Fairly easy. If there's no real estate, we just run it through the court, get a case number, and then you have the ability to go and talk to, someone about that account that daddy had. Okay. So probate for estates over 100,000 can take a long time. They're expensive. You are asking the court to tell you every step. Even can I sell the house? So keep that in mind because I'm going to tell you another way to avoid probate. Not just with your trust, not with your will, but that'll come a little bit longer. So let's talk about what is a good estate plan. Remember, I said it is unique to everyone. So be very careful when you talk to people because their situation might be a little different. And that's why you want to talk to someone and remember to review it and make it flexible. Like if I have in my will, I want all my jewelry to go to my niece, and I list specific, this ring, this ring. But if I give that ring away before I pass away, then there is no ring. So you can still give things away, but that's why it's important because then they're going to accuse the sister actually taking the ring. So be very careful with that. Um, as I said, the basic will, you do have to have two witnesses. It has to be notarized. Some people say, do I have to publish it? No, but you do have to have a statement on there that it is the will, which they do call publish, and then an affidavit. But you don't have to go file it in the county courthouse unless you want to. But if you want to keep it private, then you can keep it private. But back in the old days, when people owned hundreds of acres and hundreds of people, that was considered property. So those wills had to be, preserved. So that's how we're able to go back and trace. Oh, my great grandfather was probably this Negro boy, 20 years old, based on his date of birth. But yeah, they did record theirs, but we don't now because a lot of times it's not that serious. We don't have all of that, but it is important, even what it is. Even like a father may have different guns until his son split the guns up, and then there's a fight. So everything needs to be very, very specific. A gunfight, a gunfight over the gun. Okay, so a lot of people make trust. A lot of people are always looking for the easy way out. So I had one client, he had set up a trust, and the trust bought the house in the trust name. But when he got ready to sell it, they wanted to write a check to the trust. There was no bank account. So you have to fund your trust. Does it make sense? So you could put a house in there, but it belongs to the trust. We actually have to change the title from you to you and the trust. So they're gonna write that check to the trust. So I tell people go open an account, even if you just put the minimum in just to get it going, because it's really not a trust if it's not funded with either asset, whether it's real estate or money. Now, some people make their beneficiary on their insurance policy the trust. Same situation, okay? So be very careful. They're pushing it all on TV. You need a trust, just legal zoom it, get the forms, pay us $75, and off you go. But no, there's some steps you take. You creating a separate entity. That entity needs a ID tax number. That's how you kind of avoid some of the, why they call it, protect some of the taxes and estate taxes and things like that. So it must be funded, whether it's your house, and then the trust runs everything, paying for maintenance, repairs, but you still have to put more money in there to keep that going. So everyone, it depends if you want it. It depends if you want to sell the house or you wanted to keep it in the family. So that's every situation is so different. Most people say sell it, but I had one client. She had a lot of money. She had sold her home in Texas, made a lot of money, so she was able to fund her trust with over $250,000. But she wanted to set up a scholarship for her kids and anyone in the family. She had stipulations. So yeah, I would say you need a trust on that. Yeah, but that's a great question. Be careful because Medicaid, if you end up qualifying for Medicaid, they have a 5-year look back period to keep people, used to be 3 years to keep people from transferring assets to avoid it. So they can look back because guess what? They got access to your checking account, the government, all the computers talk now. This happened about 25 years ago. I was working at the VA and a guy came in there and he was like, they said I don't qualify for free health care anymore. I said, well, did you get any money or anything? And he said, yeah, I got a big insurance settlement, something else, some kind of settlement. And so the VA could see it. IRS, Social Security, VA, they're all connected now. And if you deposit over 10,000 cash in the bank is going to notify the federal government because you know what they're looking for? They're looking for their money, their taxes. So trust is a good way to avoid some of that. But one client she talks about in this book was giving, you can give away gifts. The IRS allows you a certain amount of money, a lifetime of 1 million plus. But every year, you could do per person up to about 10 or 15,000. It goes up. But you can give that gift away. But then the gift is not taxable to that person, but it could come back to haunt you if you got to go in a nursing home. So it's all kind of intricately depending on your situation. Yes. Wow. When one of them dies. I don't know about that first statement you made, but most people, when they have a trust, it is a couple thing. And I've seen them put the house in there, but as far as what happens, I don't deal with them after the death in a trust situation. I only help create them. But that's something that would need to be asked by a real estate agent or someone that specializes in elder law. That's not my specialty, but I do just some basic estate planning. Hmm. Okay, I've never heard that, but it's probably, yeah. Oh, well, we got a real estate person in here. You, mhm. Mhm. It's locked in, but the other one that you can change, to change it, you don't actually go in there and change the wording of the initial trust. You do amendments to the trust. Yeah, so it's whatever the trust dictates a line. Hmm. Yeah. Yeah, because the government's not going. You do file a yearly tax return on your trust, but it's not like the government. It's just an informational piece because you don't pay taxes on that. So you were gonna say something? Right. No, I was just you were saying with the trust, the house to be in, it has to be sold at the value that it was put in there. If that's how it's written. Okay. But because he said fair market, then there's no value on right. It's whatever. So whatever the fair market. Yes, you put your house in there at fair. Yeah, the truck you could you could put whatever. Yeah. And what happens like if the successor trustee or even the trustee or trustee board um, if they're not following the wishes of the trust, it's still a civil case, but what you do is I had a case like this. Some of the family members accused some of the other family members of taking money and things like that. So the case was, did they violate their fiduciary responsibility? If they can show there was dishonesty, if they can show that there was double dealing, then this side wins that's challenging these that may not be doing everything they should. And that's when you have a board of directors. You could have that instead of just one or a successor trustee. So it depends, like if you have something or organization you want to keep going. And so that's what happened. The judges hate those cases and they're going to almost always make them go to mediation. Any more questions? Yes. The judge won't see you if you can mediate it, and they'll order it. They'll pay for it. When it's messy, they'll just say, "Hey, go to mediation." And then a lot of companies, when you do business with them, if you sign that contract, it's gonna tell you either arbitration or mediation before you can file a lawsuit. So I always ask. I get those cases too. I do contracts. Oh, this company didn't do what they said. Well, let me see the contract. Most times I get, well, it was just an oral agreement. I said, okay, that's a contract, but it's hard to prove because there's nothing written. It's he say, she say. That one's probably going to mediation. But it's a cheaper, easier way to keep from clogging up the court systems because you can imagine all this he say, she say stuff and families. Oh, it gets in that judge. He's like, mediation. Mhm. Right. Okay. The It depends on what's in the contract. Most contracts now say arbitration. Arbitration is a little stronger than blush mediation because there's no real follow up to make sure those people follow through with what they were supposed to do. But the arbitrator, they are making sure it gets done. And most companies gonna say that on anything now. You're gonna find an arbitration clause. You do that before you can sue them. Yeah, and most people don't even read all that stuff. But you look at the very back, it's gonna say arbitration. Right. It's arbitration. They call it an end user license agreement. And you just scroll. I accept. I give. Yeah. So arbitration is a little bit, to me, tougher for people not to follow through. Now let's talk about some things to avoid probate and checking and savings account. I get a lot of that. Okay, I have an elderly mother. She really couldn't handle her money anymore, but strange items would start coming to the house because she would give her information out. So I'm her power of attorney. So I'm on her checking account so I can see what she's doing. Even and she can still, I mean, she can write a check in church, but don't come to her house trying to sell her something. And she, I'll tell her, okay, you could pay them with a check if it's like some plumbing services, but that's a joint checking account. Okay. So what happens is when she passes, or I may go first, whatever's in that account goes to that survivor. Okay. But in my situation, I have other siblings. So I wouldn't expect that that money would all go to me, whatever's in her bank accounts. So that's one way. The other one is a POD or a TOD. TOD is transfer upon death, and a POD is payable upon death. And that just means your whoever that parent is, and the husband, it could be a spouse, they make you the POD, so whatever's in there, you could collect. But you can't access the account or anything like that. They won't even talk to you. But if they should die without either one of those, then you do have to go through small probate if it's less than 100,000. And that way you can go and the bank will decide, you list the heirs, and then that's how they'll distribute the money. Yeah, those things you have to do with the bank. Yeah, remember I talked about the small estate affidavit? Like if it's you got $99,000 in your bank account and you don't have a POD or anyone that can write checks on your account, my name is actually on her account, my mom's account. So you will have to go to probate because the bank won't talk to you. They shut the checking account down. Access. Yeah, if you're not on there. Hmm. Yes. Right. 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 Hmm. And I've had families say, "Well, I got the ATM card. I could just go withdraw money." Now, at that point, you are breaking the law. So remember, we know mama's PIN number, and so, but yeah, I was like, please don't withdraw any money. And it's really bad because this was a case where it was a young person, younger than me, who had money in the account going every month. But once he became debilitated and couldn't walk into the bank and had not shared his uh, passwords and stuff, they couldn't even access those funds. So I think the nursing home ended up working out a way to try to help them, but I think they're still dealing with that problem. These things can go on and on and on, and I just hate it because there was just some steps that could be taken ahead of time. Um, so credit union accounts, same thing. They're going to be beneficiary driven. If you don't have a beneficiary on there, you're forcing it to go to probate. Annuities, IRAs, and Roths, same thing, beneficiary driven. Insurance, same thing. I'm not an insurance person, but it depends on your policy. But most of them allow you to have a beneficiary or more. I want 50% to go here, 25% to go there, and you could do it like that. So make sure you do that. Burial policies, I advise prepay because some people, I'm getting a prepay because if I go before my mom, she'll probably spend every little dime and have doves and just all over. I was like, I don't even want that. I don't even really want that. And that's where will could be helpful. Like this is what I want. I don't want to close. I don't want to open. They open the casket in the beginning, the end. You can specify you don't want that, even though you won't be there. Uh, yeah. You could do the funeral home, or you could get an agent. You really want a plan that's transferable, that you don't have to just go to this funeral home. They the same people they kind of like. Mhm. So I would encourage you to do that. That keeps people from being all emotional and getting talked into stuff at the funeral home. You had a question? Okay. Mm-hmm. And the only time I've seen this once, a funeral home goes out of business that has your prepaid plan. They may sell. There's a one that everybody knew way back in the day, and they kind of collapsed. So Griffin Leggett bought their prepays, but that gets a little. We still haven't been able to track down this guy's where his family's prepay is because it was one of those situations. So, mhm. 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 Oh. Mhm. Yeah. Okay. Same thing with retirement accounts. It depends. Like there may be some children, but they're no longer dependents, so they don't get the person's annuity. But if it's a spouse and it was built into the plan, then they can get money. I know, like teachers, their spouses when they pass can qualify for benefits. So those are things that even if the will says I want this done and this done, if you have these things right here done, the will can't override it. Okay, and it keeps you out of probate. You just have to trust that people will do the right thing when you're gone. You know, why is it? I've had people say, "Well, I don't really care what happens. I'll be gone." Well, it creates a nightmare for families, and it's just it could be so unavoidable. I know you don't care, but do it for do it for them because it could be years. I have a friend; she's had a probate case. We thought everything. was in order. She had rent houses. She had all kind of property. She had all kind of gifts she was giving. And one of the situations, one of the tenants just stopped paying rent. So now you got to evict them, and so it's been almost 3 years. And the lawyer had to come up with some upfront money. She got it back, but the court had to approve it. So just be aware. It just depends. Hmm.
It's maybe part of an insurance question. Life insurance, and you mentioned making a funeral home or beneficiary.
Hmm.
Maybe not a funeral home, but the contract. How does that say I want to change funeral home?
Well, some of them are transferable, portable.
Transfer. But if I wanted to, how do I execute or work out that paying give the funeral home for one change it? Still another funeral. Oh, oh.
Wait a minute. Are, are you talking to everybody? Okay. Okay. Then you need to hold that. Okay. Okay. You had a question. Question about. I'm gonna leave some time for y'all. Well, it locks in a price though. Yeah. Right. Yeah. Mhm. 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 Right. Yes. Mhm. Oh yeah, you could do it where you have the executor that would liquidate and pay out. But a lot of insurance companies for people that don't have prepay, they'll just get the insurance check. You have to sign it over, and then they'll give you the difference. But they'll ask if you don't have any money. Mhm. Mhm. Mhm.
Cheap wooden box.
Mhm.
Let the VA take the wooden box since I have
Mhm.
VA benefits,
Mhm. Mhm.
Cheap.
Mhm.
Wrap me in a quilt made by my grandmother. Do all of that. You can go cheap. You can go
Over the top.
the Johnson Funeral Home, those little young guys. They'll do your cremation for $700. That's what they have advertisement and everything. So you don't have to go with the most expensive thing. I mean, you can if you so choose to, whether the doves or the white carrier, but you
The
don't have to.
horses. You don't, and you can just leave it up to the people. But I know that that's the time when people are very vulnerable, and I have seen caskets get out of control. The whole big, oh, they got the big signs, and so it still depends on what I mean, the family. You can tell the family, but we got about 10 more minutes. I have a couple things.
We were talking about transferable. I think that's part of another thing that we're talking about because each funeral home is going to be different. So if you go to funeral home A and plan your funeral, they say it's going to cost $10,000. But you wind up with a bad experience, and then you say, "Well, I'm going to B. B, that same funeral is going to cost $12,000." So the word transferable, I think, is part of what we're kind of missing in this. It's always
Right.
it's not equal. It's transferable.
Mhm.
You have to go to whatever I say, and then there may be a balance.
Right. It's just important to just have in your mind, what is it that you want, and
It does.
I'm gonna cover one more thing. I think is I've seen common mistakes in, and that's the will says, "Oh, I want the house to go to Johnny," or split it between the four children, and that's all she does. That doesn't get it. A will cannot transfer property. Well, I got it right here. Doesn't transfer property. Only thing that transfer property is a deed. And so when your parents buy this land, or when you buy it, the deed is in your name. When you die without any other type of preparation, then a dead person can't sell a house. Okay, they can't sign. Even with that power of attorney I told you that dies. People just really don't know. And this is how they approach me. And I'm in this, I got into law late. I don't proclaim to be a expert in this, but I know everyday life. And so I'm able to refer them to people that are more capable of handling the more complex situations. But I'm starting to really specialize in property now because there are different types of deeds. Y'all heard of the quit claim deed? Okay. Well, quit claim deed is probably one of the weakest deeds because all you saying is, well, I own this, I'm gonna give it to you, but I'm not guaranteed some heirs might not pop up or anything like that. It's just a quick claim. I'm helping a couple right now. They getting ready to get a divorce and they have two houses, and you have to quit claim this back to this. It just gets really complicated. But the deeds they're what dictate how land is transferred upon death. I growing up in Little Rock, I didn't have this problem, but I have so many clients that grew up in rural areas where grandma and grandpa had hundreds of acres. Some people got that 40 acres and a mule. They got it, and it's still in great grandma's name. So then I have to go through that process. If it's over 100, I'm gonna pass it on. But it gets really complicated, y'all, when that happens. Mhm. It just states I'm the grantor. This is the grantee. I'm giving the house to you. That's all it does, and it gives a legal description, and then it's notarized and signed by me. I go record it. You go record it down at the courthouse. It's in Arkansas. It's the last file that counts. So when your filing comes in, that's what that's who owns the house at that point. So it's a process to go through to get it out of that person's name. We have to run it in the newspaper, see if it's claims. I'm still getting claims. I'm still getting claims from people that I closed their case 2 years ago. They still owe for their phone. They still owe for, and now they have my address. So I get mail constantly for clients, families that I've, and basically the estate is insolvent. There's no money to pay. So we just have to leave it. But they hound your people if you owe a cable bill or any of that. I mean, it's terrible. Well, no, if you still own your house, like then that's something different. That's a lien. If you didn't pay some medical bill, a lien. If you didn't cut the grass, there's a lien. So you have to satisfy all that. They're not gonna close on that house without those things being taken care of. And I got 3 minutes. Um, I've seen this too. Married couples that got married years and years and years ago. And Charles, I need to talk to you about this later. Um, it's only in the husband's name. And at one point, I guess that was the way it was. But then I'll have a case where a mother and a sister, and it says, like it would say Pam Abrams and Annie Abrams. And you would think when one of us passed, it'll automatically, but no, we're common tenants. We both can sell our piece of the property. Whereas the one for married couples, joint tenancy with survivors' rights, that's when that 50% comes and becomes your 100%. But it depends on what's written in that deed. You mentioned what's called a life estate. Mama does a deed. She says, I give it to them, but I maintain a life estate. As long as I live, I can live here. But then after that, it belongs to them. Okay. And lastly, one of my favorite deeds, and I tell everybody to do this too, is a beneficiary deed, whether your house paid for or not. And I'm gonna tell you the difference, and I'm gonna use myself as an example. I bought a second home. Why? I don't know. After I retired, but I still owe on it. And so, if I didn't have a beneficiary deed in place. No, I'm not married, no children. So my brother, I named him as my beneficiary. I created a beneficiary deed. It's recorded down there. Literally, the day he get the phone call, I took my last breath. He can go hire a real estate agent and sell that house. Even though I still owe Regents money, all Regents wants to do is come to the table. So that's one of the best ways to make sure who you want to get the house. He doesn't want the house. He's going to sell the house, you know. But if we didn't do that one little task, it would be months and months in probate. Who's going to pay that house insurance? Who's going to pay for that yard to get cut? Who's going to pay for your utilities to keep? You got to keep the utilities on to keep the insurance. So it gets really complicated. And that's one of the most simplest things that you can do. I hope that you've gained something from this. Most likely, it opened up more questions for you, and that's always a good thing because guess what? Learning doesn't stop. We're constantly learning, and don't forget the laws that change. So, yeah. So, just remember that if you're seasoned and you get remarried, I would advise you to get a post nup because now you got step kids, and it gets really nasty. Even if I mean, simple things like that you don't have to think about. And there's nothing wrong with that. It's called a prenup. You think only movie stars can do that. But I would advise you, to be very clear. as to what should happen if you get married a second or third time. And again, you could give gifts before you die. And remember, several professionals do this. I don't consider myself a professional estate planner, but I am an attorney, and I try to be fair, and I know my lane. So attorneys, you got financial people that are good at it. That's those companies that can handle your financial planning and really help you with your estate planning. You're gonna need a good tax advisor if your estate is like this, and to avoid taxes. And then you have people that's all they do is estate plan. So I agreed to do this because I just like getting the information out, doing basic estate planning. But I would advise everyone to take one or two of the steps I asked you to do to secure your peace of mind and and to for your loved ones. Okay, any questions?